In this vlog, I'm going to be talking about how to respond to a bogus New Hampshire employee claim. You could have it with the Department of Labor for maybe it's a whistleblower claim under RSA 275E. It might be a discrimination claim both under federal and state law depending on the size of your employer, and it might be, and therefore being that the New Hampshire Commission for Human Rights. In either dual filing with the EEOC, and in any of those cases, take the time within the time allotted that the agency tells you to do it to really spend some effort in it. The logic and the thought process of many of us is the case is so silly, everyone's going to be able to notice it's silly, so I'm going to be dismissive on this. I'm going to waste time with this guy or gal who absolutely deserved to get fired, and everyone's going to make it very easy. You want to make them see, the investigators see that extremely clear and not have to work for it. Give them all the details. Give them the verified statements of yourself with the co-employees. Give them the warnings if you gave them warnings before of this employee, so they see what the performance issues are. If it was one serious issue, explain that situation. I've had situations where somebody actually made threats and the police were called. Get that police investigation included in there. So it's very serious, and the investigators will then see that the case is not worth them having high priority on it because they're understaffed, and they are going to be looking at the cases that are going to make a difference to the employees in this state. And if these are bogus claims, it's going to be probably at the bottom of the pile, and you don't mind that being that way. And you also don't want a lawyer that's looking at this case later from the employee shopping it around to see a dismissive response by the employer. If they get a good detailed response and they see that the employer has game and they did everything the right way and this is a solid firing, that the person deserved to get fired, the employee counsel is not going to be convinced to take it on a contingency fee, meaning that they get paid if the employee gets paid. They're not going to want to do that when they see that the employer has very good defenses to this. So take the time to do that. You also want the investigator, who's very interested in getting to the truth of the matter, to be able to get to the truth of the matter fast. And when you provide it and you lay it all out on a silver plate, you give them the verified statements for them to talk to, all that makes sense. Also, for those people that you get your verified statements from, and I deal with this when I'm representing the employers, it helps get the employees that know about this case now versus months or years from now to remember what they said back then. And this is not somebody being intentionally deceptive later, but memories fade. And if they all put it into a very clear statement before, when this investigation was just happening, when this claim was just happening, if months or even years later they're looking at this situation, they're giving back their statement, it's going to refresh their memory. It's going to help them. And it's also very helpful if that employee later on, for some other reason, leaves the employer and maybe doesn't have the same loyalty to the employer, or might be mad at something else that happened with the employer. You want to make sure that they are kept to the truth of the matter, and what they said in the beginning and they put under oath is going to be the truth of the matter. So you want to deal with that ahead of time. So those are all extremely important factors. Spend the time, hire the lawyer to deal with the issue. Don't take it dismissively because you want them to deal with it. You also want the investigator who's overworked on this situation in the Human Rights Commission particularly to not focus on it and let it sit. They can go up to 2 years of not doing anything on it, and some of these cases do die by inertia. The people just move on and they don't do anything else with it, or they don't find a lawyer involved in the case. So if it's a bogus claim and the investigator gets to learn that it's a bogus claim fast, then both the employee loses interest and the investigator loses interest, and that's not a bad thing for you as an employer. So it's worth putting that effort in. If you have any questions in regards to this or anything else in regards to employment-related issues or other issues, you can check out our website at nashualaw.com. That's Nashua Law, all one word, no space, .law or .com. And you can call me directly at 603-883-5501. Our firm's telephone number again is 603-883-5501. Look forward to the opportunity of working with you if the opportunity so arises. Thank you.